If you want to really have if you really want to have a good pleading, good kind of plan written, then as a good lawyer, you must know everything, and there is no other better source to know it that this the client is telling you. He knows it. And here, I would not just ordinarily people would go, okay, appellant has these parts and this. No, I want to prepare you, give you an idea that how you can be ready to write it. And it's good you know its parts, but the question is, how will you best write it? So you have to get the knowledge of it. And I will again connect it with your assignment in college or university. Now, when you get an assignment, you must first know the related literature on that topic. And if you know it, then you write a very good assignment. And if you give it time, you write a very good assignment. If you don't have the time and literature available, then you know what one does. So here is not a choice. There you can get 5 marks out of 10. Okay? That's a choice to you. But here is no choice because you are taking the case of someone. That's very important. His interest is involved. It is sometimes in lakhs, sometimes in crores, sometimes in hundreds of crores, and in a big way. When it is a claim, it involves respect also, your respect, their respect. So it has to be taken very seriously, and you have to get into it as a thesis, as a dissertation, that here this case has come to me. I want to go very seriously into it. I want to understand it. And then this time the client knows more. But after the client tells his story, I must know more than what he knows. Because I am a trained person, I am a lawyer, I am an advocate, I have undergone the studies, I know the perspectives, I know the possibilities, I can have the assumptions, I know the analysis of it. So, you can't do it. What people generally, it's very unfortunate when these pleadings and drafting are taught. This aspect is generally ignored, but I want to emphasize this aspect more, that you have to prepare yourself for that, and that's how you must be a lawyer with very good this client interviewing skills. Because your case will be weak or strong, your pleading will be weak or strong, your this arguments at the end will be strong based on this thing, that how much you were knowing, how much you had actually gone into the issue, gone into the matter. And that's how client interviewing, client counseling also, it becomes a part of the process of getting to the pleadings. That will also determine that what sort of pleadings you will go for. And that will also determine what sort of cases it will lead. And then also this will lead to what sort of relief you can claim. And then it can also give you the knowledge of strengthening that how I shall agitate the cause of action. It's not that you are going to a playground to play. It is, even now playground may ask you that whether you are entitled to play here or not. And more so clubs will ask you about the membership of it. And to the court of law, definitely you are a citizen of the country, you can go. But they will ask you something, that whether you have come to waste our time, or you are wasting the time of the client, you are wasting your this thing, that thing. At the first instance, when you think of drafting a very good plan, then definitely at that time you have to have a very good interview with your client, depending on the nature of the task, whether it is of matrimonial nature, it's an ordinary property dispute, or it involves some aggression also, it involves some kinds of offenses also, whatever. The whole story goes with that interview. Then once you are well with it, then definitely you can see that what sort of line of action you should take as a lawyer. Might be sometimes you feel that it will be good to suggest to the client that let you have an outside court settlement. You feel so that it will not be, as a very good lawyer, you are not just engaging the people into these litigations. You are advising, you are counseling. Yes, definitely you are charging fee also, you must charge. But at that time, your counseling should be wise. And that wise counseling will depend on these. And here at this stage also, you have to have very good skills of maybe you will have some kind of agreement, some kind of undertaking, sometimes kinds of promises amongst the parties that you can know the best only when you have a good thorough knowledge of these, of the matter, of the case, and then of the relevant law. Having said it, I may say once you resolve that I must go for the litigation and I must file a suit. If it is a civil matter, you feel we have to file a civil suit, then my advice to you will be that please, read some good book. We do have some ordinary textbooks on civil procedure code in various law libraries. But please have uh, a look on some good book for making a distinction on that which is a civil suit. As Section 9 of the Civil Procedure Code that limits the jurisdictions to the civil matters, civil issues. So you have to ensure it that you are treading a path which is safe for you, and you understand that this is a civil matter, and therefore I am going to with this. Now, many times, some lawyers they feel that there are certain things which are of criminal nature, conflict between the two parties or multiple parties, and they think of initiating some criminal proceedings also. So the mind is open. You have to, since you have entered the battle, this is a battle, and this battle has to be taken very seriously. And again, I will tell you, the conclusion will more depend upon how sound your writing is, your drafting is, how clear it is, how meaningful it is, and how comprehensive it is. And then at the same time, it avoids all those things which reduce its this value, its effectiveness, and where it can be attacked, where it can be then reduced in its value, in its claims, in its certainty. Here it has to be again seen, and that's how in the civil matter you have to then choose for that which court is relevant to it. Once you have seen that what is the matter, what is the conflict, nature of the conflict, and then under the law, under the umbrella of law, what are the various kinds of remedies available to my client. Uh, so it should not be like, a lawyer should not grow like a toad in a pond, a frog, as you find, is in a pond. They live somewhere and then they only imitate things, and somebody is, taking some line of action and they always follow it. No, you must become a very good lawyer, client-oriented lawyer, relief-oriented lawyer, and then you have to see that where shall I get the best relief for my client? And sometimes you may avoid this, some kind of litigation, and you may resort to another thing. And sometimes you may avoid not getting to the criminal side, but getting to the civil side. Sometimes you may say, no, my things will be done only through consumer protection. Or sometimes my task will be by getting to some other tribunal is giving a special court is giving the relief, which will be easier or like that, and then there are lesser procedural wranglers, whatever. So at this stage you would have to be very clear about all these things. That happens only when you get, before drafting your pleadings, you must study the law. One of the very important principles is that you have not to plead law in the pleadings. You have to, but it does not mean that you can write a good pleading without knowing the law. No, you must know the law. In the light of that, you must do it. And then accordingly, if you are not knowing the law, you may write anything. Yes, it can also be possible because you will write a long story. You are not focused, and then when the opposite party will come, they will attack you. There is much, when you write too much, there is much that which on the basis of which you will miss the matter. You will lose the case. So this once you understood the nature and then you decide the course, then you will decide to which court I should go. And then facts will tell you whether you have to go to a small causes court, to the district court, to the high court, or anywhere. So that's how you have to decide on the basis of the subject of the property involved. What is the property involved? What is the volume, pecuniary, as jurisdiction, as we call it? How much is the value of the this property involved in the matter? And then accordingly, you will choose the forum where you have to go, which court where you have to go. That has also to be decided before you pick up the pen or before you get to your laptop or computer to have to initiate the stroke for writing or drafting. And then one more thing which has to be kept before that in mind, that you must have a good command on the terminology which will be needed by the explanation of this case, by understanding of this case, and by arguments in this case, and for description in the pleadings in this case. So please, as we have most of the times pleadings in English language, then even if you have done LLB, how does it matter? Somebody has done PhD, somebody this, but still consultation of dictionary or law lexicon or a thesaurus should be consulted. It's not bad. And even, every statute has an interpretation clause. And you must look to the meanings of the terms, what are given in that relevant statute, because that gives you basic sound knowledge of it. See, it's you can understand it. If somebody starts writing without getting to the terminology which is appropriate for a matter, and with the knowledge and with the terminology which is appropriate, and one which is not appropriate, then so the choice here is no choice, that one has no to feel shy that he has to consult a dictionary, he has to consult a law lexicon. No, every time it must be on your table, and you must see it that I'm using proper terminology, I'm using proper words, I'm using the words, which actually will carry the will of this your client, and then it will be something which will not be objected to, or which will not reduce the value of your case in the court of law. So, dear friends, this all what I'm saying will apply to any pleading. It may be as regards the petitions in the High Court, petitions in the Supreme Court. There will be some structural variation in plans and petitions, or maybe in the written statement, and then affidavit and all that. But there is no alternative to what I am saying, that all must be with you. As I said, that should be the first task once you decide to take up a case of any client. So coming back to, as I said, I shall not focus on all these things. You must be having some lawyers also to speak here. So I'm taking a very primitive thing. That's, the plant, as I said, that if one writes a very good plan, he learns to write a very good petition for High Court, for Supreme Court also. Because, the main crux of it is the same. The crux is that when you learn, something, as I talked about the assignment, if a student takes seriously the writing of an assignment and writes it with due concern, to him, it's not difficult to write a very good dissertation, because that's only a multiple of it, but it is the same. And in the same way, when you write a PhD thesis, it is also a multiple of the same. But it is, you have to write more about it. As I say, multiple of it. And otherwise, it's the same thing. In the same way, when you learn to this listen to the client, make out the ground for him, understand it, and then ultimately you decide that to which court I should go. And then at that time, you'll begin by writing at the top of the plan that the name of the court, whichever court it is, and then also, you have to determine the jurisdictions from the point of view of territory, from the point of view of this value, as you have to determine the value of the subject matter of the suit also, and you have to see also the area where it is located, and that's how, when you will write at the top, as you write in the court of this in the court, you must have seen, and seniors will tell you that thing, that it may be in Dwarka, it may be in this Noida, it may be in this Rohtak, wherever it is. So you have to write it accordingly. And then with much clarity, there should be the names of the parties. You may be feeling that I am taking you back to that LLB class. Not bad, because when we get to the class, after learning more then we find that that classroom would have been made more beneficial if I was serious then, and study more of that. Probably there was no need for these lectures if that classroom was taken very seriously. Here the question is of identification. Court has not its own, identity of the persons, because it is the court knows only the advocate. Advocate, as we have also uniform for advocates in our country, a particular one, maybe in almost everywhere some distinction is there. So they know only this person, and you are going there. And that's how any person you are carrying, you have to give a full description of the name, the parentage, the place of residence, and whatever. And this may keep changing. Maybe someday some more identity may also be given, but whatever is required this time, that must be mentioned about the person. It's the plaintiff, and then also against whom this case goes. He is the defendant in civil matters, as we have the plaintiff and the defendant. So it will go there with full description of the parties, all those minor things, date, this thing, that thing, that thing, that will always be there. Dear friends, once it is natural. No, you can yourselves think what should be written in the plan. It is natural that you must have the submission. It's natural that you must put the name of the court. It's natural that you must have a clear description of the parties. So natural. And then other components also are, if you think naturally, you will yourselves think of them. Though there is, a very good precedence now, clarity, rules, other things, they are there. But at the same time, I'm thinking a clear mind can understand it and remember it for all times. And that's how, when you get to other parts of the plant, there, what you have to now describe, which is the next most important thing, name of the court, then parties we have defined, and then, facts, you have to come to the court with facts. And Actually, any case is based on facts. And what prompts you to go to the court are facts. What gives you strength are facts. What makes you weak are facts. And what nullifies your case are facts.